We are obviously here to talk about some serious issues and talk about the ramifications of the BP oil spill and the potential claims that banks may have. And so we're delighted that you've taken the opportunity to be here this afternoon and be a part of this. I have the pleasure and the privilege of introducing a number of people in today's audience. And, you know, anytime you get that privilege, you leave somebody out. So forgive me if I've done that. We'll try and cover that at the end. But let me begin by thanking Fred Levin and Mark Proctor with the Levin Papantino firm out of Pensacola, who are to my left. We thank them very much for being here. From the Shelby Roden firm in Birmingham, David Shelby in the back here from Birmingham. Jody McKelvin is here. James Bell also with them as well back here from Alabama. Malden Jenkins has Bill Curtis here or scheduled to be here, I believe, out of Birmingham. Let's see. There he is right there. How you doing, man? Warren Averett out of Pensacola. I know Jeff DeWeese is here to my right, perhaps others with that firm. Carr Riggs and Ingram has with us today Mike Scott and Ashley Wheeler. Chris Kane and Doug Mims may be here or may be on his way, and perhaps others as well from Carr Riggs and Ingram. Mr. Carr is here as well. Thank you very much. From Gulf Coast Community Bank and a part of our panel, Buzz Ritchie, to my right down here, president of the bank there, and he'll be talking a little bit about his perspective on the claims and how that's certainly impacted his bank. Alex Hager is here, former interim commissioner of banks in Florida, now with Saltmarsh. Alex, right back here, there he is. Thank you very much. Greg Rains with Center State Bank is here as well. And finally, I get to introduce to you my good friend and our superintendent of banks in Alabama, Mr. John Harrison. John is going to kick us off today, but again, let me welcome you and thank you all for being here. And our hosts out here to the right have been very gracious to get us all set up. If you have any needs during the meeting, be sure and signal, let one of us know. We'll be sure and take care of you. John, thank you for being here, and I'm going to turn it over to you.
Thank you. Yeah. Oh, we got a cord and everything. It's my pleasure to be here this afternoon with you, and hopefully I think my title this afternoon is moderator, but I won't really be moderating anything because we got a great program lined up of experts who have been working on this for quite some time, and we want to make sure that they have time to make their presentations and then mainly to be here and answer any questions that any of you might have before leaving this afternoon. I would like to introduce two of Alabama Banking Department employees who I wanted to be here just in case there was anything that they needed to answer or they needed to hear, or if you needed to break out and have some one-on-one with Wayne Cranford or Nelson Cook. Both of them are available and hopefully can answer any questions that you might have individually or collectively along with myself. I want to just try to give you a quick overview of how this process got started and where we are and hopefully where we might end up. But right after the oil spill in 2010, Governor Riley called and said, "John, I think you need to get to Mobile and talk to all our bankers and make sure they understand if this becomes a problem that there will be some restitution and there will be some claims money available to them, but more importantly, go down there and get all the banks together and talk to them about taking care of the constituents of Alabama, their customers, and let them know that it's going to be processes for business, for individuals, et cetera, et cetera." Well, you know, I should have thought of that myself, but I didn't. But anyhow, I went in his direction, and actually we came to Bank Trust's old building right over here, and I think we had about 30 or 40 banks and bankers represented that afternoon to talk about the implications that we could face or that we would face with the oil spill, not knowing what was going to happen. Anyhow, we had BP was there, and they said, well, we're going to have claims offices set up A, B, C, and D here, and all you're gonna have to do is go in there and fill out your claim. Then we're gonna cut you a check. Well, you know, that sounded pretty good, and we got to thinking that we would make sure we got that message out and take advantage of it. Well, some of the claims that were filed were getting paid. A lot of them were not, so we got back and we stayed in contact with BP through the governor's office, and we had a conference call every couple of weeks or every time we needed to try to give up to date or give encouragement about which way this system was going. And quite honestly, the claims were not being paid to everybody like they should have been, but it seemed like that the banks and all the financial institutions were just getting left out completely. And so we kept in touch. The governor stayed, he stayed in touch, and finally one day we get a call and said, well, you know, we got $20 billion being put up, and they're going to send somebody in here named Ken Feinberg, and he's going to take care of the banks and the financial institutions. Well, that was very welcome news. So we emailed back and forth to our banks and said, if you got a claim, you know, we're going to have a little more hope, hopefully, and here's how it's going to be. And Mr. Feinberg is going to be the person that will be guiding us in getting us the recoveries. Well, I personally chased Mr. Feinberg down twice myself and had an individual one-on-one meeting with him to find out how we went about getting a claim for our industry. And I'm not sure that I know that answer today. He was evasive. I don't think that he ever told me the real truth. And he would say, you need to do this, and do that, which we passed out. And I'm not sure that any of our banks got any money. And finally, working with accounting firms, attorneys, and everybody else, I think we just got sort of given out and hopefully anticipating that maybe it would come, but it just never did come. And so finally, about 2 months ago, my good friend from Crenshaw County that I've known a long time, that one of our Alabama bankers, James Bell, called and said, John, I think there's some new discovery on the BP oil claims. Would you let me come down with David Shelby and talk to you about that? I said, James, I would be absolutely thrilled to do that. So here we are today, and my intent and the state banking department is that we hope that any bank, whether it's an Alabama state chartered bank, whether it's an Alabama national bank, or whether it's a Mississippi, Florida, anywhere that was damaged and had loss as a result of the BP oil spill, will have some reasonable way to get a claim filed and have restitution paid to them. I've only been involved with this group a short time this afternoon, but what I've heard for that, I've been really impressed, and I really think that maybe we, even though we're on a fast track, we finally got a chance to hear some things that would give us hope that that claim out there would be collectible. So with that, I'm going to turn it over to Mark Proctor.
Thank you.
Yes, sir.
Thank you, John. Good afternoon. My name is Mark Proctor. I'm the president of the Levin Papantonio law firm. My partner Fred Levin is here with me. We are lawyers who have our offices in Pensacola. We're involved, as our friends Beasley Allen are, both in the national BP litigation as well as handling a myriad of different claims throughout the Gulf Coast region. I want to take a few minutes and kind of set the stage. I want to tell you how we have gotten to where we are, both with regard to the litigation in general and to kind of explain where we are with regard to bank claims. Immediately after the spill, in April of 2010, the federal court system reacted, as it always does, to a very large tragedy like this that spans an entire region of the country. We call it in the federal system multi-district litigation. And what the federal court system does to try to eliminate repetitive trials about the same issue, to try to avoid wasting time and money in the federal system, they consolidate the matter in front of one federal judge. And that's what was done here. It was consolidated, the BP litigation was consolidated in front of Judge Carl Barbier, who is a federal district court judge who sits in the Eastern District of Louisiana, New Orleans. And Judge Barbier was tasked with bringing the parties together and conducting as much as he could of pretrial proceedings, trying to get the discovery underway, how the accident happened, the myriad of issues that get dealt with in a lawsuit of this magnitude, and as well to try to resolve, either by agreement or by rulings, as many of the common issues as could be resolved, so that at the end of the day, if there are a bunch of claimants trying lawsuits in various federal district courts throughout the Gulf Coast region, that there would be certain issues that would already be resolved. And so what Judge Barbier did to organize this is he's got the defendants on one side, he's got the myriad of plaintiffs on the other side, and to organize the parties, he appoints what we call steering committees. A steering committee of defendants, representative of the various defendants, and a steering committee of the plaintiffs. And it's called, in the jargon, the Plaintiff Steering Committee. In this case, it was made up and is made up of 16 different law firms across the Gulf Coast. Our firm is a member of the committee. John's firm, Beasley Allen, is a member of the Plaintiff Steering Committee. And then that Plaintiff Steering Committee gets led, in this case, by 4 law firms. We're one of the 4. It's our firm. It's the 2 firms from Louisiana, Jim Roy's law firm, Russ Herman's law firm, Steve Herman, and then Barron and Budd from Texas. And so we 4 firms lead the Plaintiff Steering Committee, and it's our job to marshal the plaintiffs and try to move the litigation forward. And the way the litigation gets moved forward in a process like this is the judge sets what he calls representative or bellwether trials. These are trials that are intended to resolve major issues in the litigation, and also along the way hopefully cajole the parties to get together and try to solve issues and potentially and hopefully settle the litigation. And so the first trial was scheduled to begin on February 27, 2012. The parties had been litigating ever since the spill, taking hundreds and hundreds of depositions, getting the case ready to go to trial. And the first case was to decide the relative fault of all the defendants, how the tragedy occurred, who was responsible, and if more than one party was responsible, who bore what percentage of the responsibility. Judge Barbier, and I think rightfully and smartly so, thought that the defendants would probably not get real righteous about settlement unless and until they knew who bore what responsibility of the cost. As you'll remember, there was a lot of finger pointing going on. You did this, no, you did this. And so that's what the first trial was going to be about. And then to bring additional pressure, the judge decided we're going to investigate in this trial the conduct of the defendants. Did that conduct, was just an accident, or did that conduct rise to the level that maybe one day in the litigation a claim for punitive or punishment damages would be supported? And so those were the issues that were going to be tried in February of 2012. During this process, as John said, the Ken Feinberg machine on behalf of BP was putting most people off, settling very few cases, ducking and dodging, but, you know, doing probably a good job representing BP. Originally, Ken, who we've known for many, many years in other litigations, was going around telling people he was impartial and neutral, and we had to go to the judge and say, you know, he can't lie about that. He's being paid by BP. He's representing BP, and people need to know about that. So the Gulf Coast Claims Facility process was underway, but what most people did not know is the pressure cooker was building up in advance of this February trial. Some secret settlement negotiations began at the highest level of the plaintiff steering committee with the highest level of the upper echelons of BP. And the negotiations took place out of the public eye, and when we got to the Sunday night before the Monday trial, the negotiations were far enough along so that BP said, you know, let's go to the judge and let's see if he would put this trial off 1 week so that we could at least agree in principle. And so we said, okay. We went to Judge Barbier. We said, Judge, we think we can get an agreement. We may have to take a little while and put some meat on the bones, but we think we can agree in principle. And the judge said, I'll give you a week to do that. And if you'll recall, on March 2nd of this year, this settlement was announced. And on March 2nd, the Gulf Coast Claims Facility died, and this settlement came into existence. It took about 45 or 60 days to put the meat on the bones, to flesh out the specific provisions of the settlement. And then, as you know, the settlement office opened up in New Orleans, a new settlement office with a new procedure, a new methodology, June 4. The settlement did not attempt to resolve or settle all claims. My prediction is that at the end of the day, this settlement will probably resolve about 70% of the litigation across the Gulf Coast. That is an amazing statistic for a settlement that got agreed to and preliminarily approved by the judge 2 years after the spill itself. That is unheard of. Everybody's familiar with the Exxon Valdez. Everybody's familiar with the fact that that case wound its way through the federal court system to the United States Supreme Court 23 years later. Very few people have been paid. So the quickness that this project moved to a settlement is a tribute to Judge Barbier. It's a tribute to the Plaintiff Steering Committee and the Executive Committee, because a lot has been accomplished in a very short time. But things that either were non-starters with one side or another, or were simply too difficult to get agreement, got laid on the table. Financial claims were one. This is a settlement that does not purport to settle all aspects of the litigation. No government claims will be settled in this settlement methodology. No bank claims, no financial claims, no real estate development claims, no insurance claims. Whole hosts of categories of claims got laid on the table to deal with later. As John said, as you know, Ken Feinberg and BP have turned a completely deaf ear from the very beginning to bank claims. They have taken the position immediately out of the blocks that banks do not have claims, that the borrowers suffered losses, that the borrowers could file BP claims. If the borrowers could prove their claim, they could get money, and they ought to pay the banks back what they owed the banks. A very kindergarten approach to bank losses, but that's the position that they've taken, and that's the position that they still currently take. So where are we now? We lawyers, or a few of our law firms, Beasley Allen one, we're another, two of the big players, David, we recognize that particularly beginning in 2008, 2009, when the deepest recession since the Great Depression beset our country, and beset our region that the economic fabric of the Gulf Coast clearly were the community banks. The national banks were not loaning money. The community banks were what we had. They were suffering. Your banks were suffering with the recession. But the oil spill dealt to some a death blow and to many a near knockout punch, because the myopic and kindergarten approach of BP that banks had no losses above and beyond the opportunity to get repaid by borrowers after BP claims was ridiculous. And so we got involved, we got interested, and we began doing the analysis and concluded what you know, that bank claims are good claims. Bank claims are viable claims, and bank claims deserve to be compensated by BP. So we got involved in representing banks, initially in Florida, and we have been advocating the interests of banks for the last 2 years, both with Ken Feinberg individually, with BP collectively, with the Gulf Coast Claims Facility as a collegial body. And yet, as we sit here today, a deaf ear has still been turned to banks. But we hope and we believe through the litigation process that that will change. Here's how it's going to work. Entities, businesses who qualify for the multi-district litigation settlement, as you know, you're reading in your paper, you're reading in the press, they're processing their claims, they're going through the settlement process, they are granting BP releases. The settlement facility has been extraordinarily slow at the beginning. They seemed to sleep for the first 3 months. They were working on their own internal issues, but in the last several weeks that has seemed to begin to turn around. They are processing claims, they are calculating claims, and so we're hopeful in the next 30 or 60 days we're going to see the landscape open up and a good number of these claims going through the settlement mechanism will get paid and will get behind us. As we know, Judge Barbier conducts a fairness hearing in a couple weeks. He will have to determine as the judge that the settlement is fair. There will be a public hearing held in New Orleans. People will come and support the settlement. There'll undoubtedly be some objectors to the settlement, and then the judge will issue an order, and we're hopeful that he will determine that this is a fair settlement, because remember, at the end of the day, even if it doesn't settle everything, it will hopefully settle a large percentage of the litigation. There is something in the law called a statute of limitations, a time period after an event by which you have to take legal action or be forever barred from taking that action. You and the other claimants in this litigation get their rights by and large from the Federal Oil Pollution Act. This was a piece of federal legislation enacted after the Exxon Valdez tragedy, and it probably won't surprise you to know that it was enacted to protect oil companies. But in part of that protection, it did give claimants a right to bring claims for economic losses caused by an oil spill. And this is where you derive your rights and the other claimants derive their rights. And there is a 3-year statute of limitations on bringing claims under the Federal Oil Pollution Act. Well, if the spill occurred April 20th, 2010, then by April 20, 2013, everybody must file their lawsuit or be barred. Now, admittedly, that's a conservative date. People will argue, well, you really didn't know you had a cause of action until oil hit your beach. In Pensacola, we didn't have oil on our beach until the last week in June. But we believe in being careful about statute of limitations. John's nodding his head. They do too. And so, the reasonable approach is all lawsuits must be filed by April 20, 2013. There is an additional provision in the Oil Pollution Act that says that before you can actually file a lawsuit, you must do a presentment. You must make a presentment against BP. A presentment is a statement of your theory of recovery, a statement of your damages, and a some certain settlement demand. You have to have documentation, you have to attach your documentation, and you must give BP 90 days to respond before you can file your lawsuit. So if you play with the clock, the hands of time, if the lawsuit's got to be filed by April 20, you pivot back 3 months and you quickly realize that your presentment must be made in very early January. We're going to say, just for easy reference, New Year's Day, January the 1st, you must make your presentment against BP so that they have 90 days to respond. They're going to deny the presentment. They're not going to, for the first time, start writing checks based upon presentments. They're going to deny them, but you got to make them, and you got to give them 90 days before you can file your suit. So you got to do two things from where you're sitting. You've got to decide, do you have a claim to make? If so, you've got to get your claim evaluated. You've got to get it evaluated quickly because you've got a presentment due January 1. Then you got a lawsuit you got to file by April the 20th. This is a very, very short timetable. We're going to talk to you specifically today about bank claims. But you do have claims. You do have significant claims. You do have claims that can and should be brought. So if nothing else, leave here today and understand that you are in an incredibly tight time deadline to move forward. And if you miss these two dates, you're out. Doesn't matter what your claim is. Doesn't matter how good it is. You will be barred from bringing your claim. Where do we think we will go with bank claims procedurally? What are we talking about when we say we'll litigate the claims outside of the settlement process because they don't qualify for settlement money? We are talking about litigation. What does BP now know? BP knows that there are a multitude of claimants. They know that some are going into the settlement. The opt-out date is November 1. The settlement is not compulsory. You don't have to go into the settlement. If you think you're better off trying to prove your damages in court, I think you're wrong, but you've got the right to litigate even a claim that could be in this settlement. After November 1, BP will know who's in the settlement and who's out of the settlement. They won't exactly know how many people are going to file claims in the settlement because Judge Barbier has given 2 additional years to file claims, but they will know who's out. They will know who's opted out. And when you're opted out or excluded, remember, you've got to make presentment and you got to file a lawsuit. So that by the summer of 2013, BP will know what its universe of cases to be litigated is. Why? Because lawsuits will be filed. And so BP will know how many banks are going to pursue this and how many have fallen by the wayside. We believe that as the litigation moves forward and as BP begins to get its arms around the number of bank claimants, they will have presentments for each bank stating a settlement demand. They will have lawsuits detailing theories of recovery. We believe at that point BP will start warming up to the idea of perhaps sitting down and talking. Can we ensure that at any particular time? The answer is no. Why? The way the multi-district litigation process works, all litigation across the Gulf Coast is stayed and transferred to Judge Barbier's court. Judge Barbier is going to keep his process open, certainly throughout the claims process that goes through April of 2014. And as long as he feels he is still accomplishing things. Accomplishing what? Settling cases, bringing parties together, or resolving common issues. When Judge Barbier says, I've done everything I can do, then he will dissolve the multi-district litigation and remand all the cases that have not settled back to the various courthouses across the Gulf Coast from whence they came, where they were filed. When will that occur? I can't conceive that it would occur earlier than sometime in 2015. Could be later than that if he's still making progress. Then the cases get sent back, and then the lawyers representing the various claimants can begin getting the cases ready to go to trial. The average time from filing a case in a federal court to trying a case is a couple of years. So if these cases go all the way to trial, the bank cases, the other excluded cases, the opt-out cases may not get to trial until 2017, 2018. But that doesn't mean that along the way there will not be opportunities to settle. That doesn't mean that there won't be places and times where we can have dialogues with BP. One thing BP will know is that you are serious, that you've got serious claims, and that you are armed with a battery of lawyers and law firms who are capable of doing battle with them, both from a standpoint of expertise, from a standpoint of financial wherewithal, and from a standpoint of experience. BP and every other major litigant in this process knows who the real firms are, knows who the firms are that know how to try cases. And I can tell you, I've been practicing law 38 years. This guy's been practicing law over 50 years. There is one thing and one thing only that settles cases, and that's fear of trial. There is a reason why BP came to us Sunday night before the Monday trial and said, let's go talk to the judge. There is a reason why Judge Barbier sets trials. Trials produce settlements. One thing that a big company hates more than anything else is putting its potential liability in the hands of jurors. If business decisions can be made and liability can be costed out, that's a process of doing business. But turning it over to jurors is a scary thing. So, the quicker and the more forceful that you show trial, that you are capable and committed to going forward with your case, the better. There is an old adage that there's strength in numbers. Folks, it's true. There is strength in numbers for a lot of reasons. Number one, you make a greater impact when you are armed with colleagues who have like claims, because it becomes too big of a problem for BP to ignore. There is strength in numbers in a litigation strategy because the costs of litigating, which are incredible, can be spread out among the various banks and clients who are using the services. This makes the costs, even though they're advanced by the law firms, more spread out and more economical for you. So the message today, from a global standpoint, is you've got claims. You've got claims that not only you believe in, but we believe in. You've got claims that are not eligible to be settled in this settlement methodology, that have to be dealt with outside of the settlement. That right now is litigation. But litigation always produces dialogue, and most of the time it produces settlements. So this is not the beginning of a long haul for us. We've been involved in this from the beginning. This is not the beginning of the long haul for you. You know what this spill has done to you. You know that there is a difference in the effects of the spill on your business and on your assets, separate and distinct from the economy. There is no question that BP was very lucky to have this tragedy occur in the middle of the deepest recession since the Great Depression, because from the standpoint of legal causation, the waters will be muddy. But we've got ways through expert witnesses and analysis of untangling those webs and representing your interests and presenting bank cases in a way that judges and juries can understand. The evaluation process that goes into evaluating a bank case is very specific. It's very thorough. It goes through all of your assets. It weeds out those that are not related to the spill, and it keeps in those that are related to the spill. In a few minutes, I'm going to introduce Jeff DeWeese, who is a partner with Warren Averett, O'Sullivan Creel. Many of you know that accounting firm from Alabama and Florida. Jeff has been working on bank cases with us from the very beginning. He is extraordinarily knowledgeable. He is going to take you through an evaluation of a bank case. He's going to talk to you about what goes into the evaluation, what types of things we are looking for. We have other accounting firms who are equally as geared up for this. We've got Carr, Riggs, and Ingram, who you all know are involved in this. We've got Saltmarsh, Cleveland, and Gund, another very large accounting firm in Florida who are involved in this. We are ready, both in terms of legal talent, forensic accounting, and then as importantly, our team of experts. From James Bell, who you all know, to experts in the impact of the spill on banks and other businesses. Our team is put together. Our team has been functioning. Our team is ready to go, but things have to be done very quickly. We know that there's some practical issues involved in your thinking. You bankers are not litigious by nature. You are conservative by nature. You are very protective of the confidentiality of your clients and customers. And there is a natural hesitancy to get involved in something like this. I'm going to introduce Buzz Ritchie, who is the president of a bank in Pensacola, the Gulf Coast Community Bank, who decided that his bank was going to get involved in the claims process very early on. and he went through this same question in his mind. I know from a legal standpoint, a damage standpoint, I need to do this, but is this the right thing to do for my bank? And so what I'd like now is for Buzz, who's got to go to another meeting at 4, to share with us some of his insights, because he's worked through some of these issues and questions that I know you're thinking about now. Buzz?
Thank you, Mark, and I'm sorry I'm going out of order. Jeff should probably talk to you first, and I'd follow up, but we're doing what a small community bank does. We're having a bank-wide United Way meeting tonight, and they told me I still have to show up. Let me just say that what got me so started about this, we had a piece of REO sold under contract a month or 2 weeks before the oil spill. 2 weeks later, the buyer on the contract said, I'm going to forfeit my little earnest money deposit. I will not close because of the oil spill. It was in writing. A couple weeks later, a month later, we resold that property for a $40,000 or $45,000 shortage. So I'm thinking to myself, I've got a pretty good claim, and I had the luck of sitting in with a Ken Feinberg show and tell a couple of times, and I'm listening to what they're saying. So I said, well, at least on this one, I'm going to get my $45,000 back. Well, all we did is get the same runaround. I don't know if you use that term, John, but from Feinberg himself, as well as his team, the claims team just wouldn't deal with it. They didn't literally say no, but they were just stringing it out. Well, in the meantime, you can imagine, and oh, by the way, at Gulf Coast Community Bank is about a $200 million bank only in Escambia and Santa Rosa counties. So every single loan I had was somewhere in that oil spill footprint. And I was watching other things happen. And I was listening to some really good friends, business owners, customers or not, getting the same kind of runaround. And it kind of made me mad. I guess maybe because I had a law degree, I paid attention to this maybe a little bit more than some other bankers would. Maybe the fact that we're so small, I watch everything that goes in and out the front door and the back door. And I just followed this process, and this is just not right. And we got together with the Levin firm. We had heard that they had some interest in this. And we also knew Warren Averett, O'Sullivan Creel, and the other CPA firms are in this. And it seemed to make a lot of sense because I realized my team didn't have the ability to put together the numbers, the financial impact of all the different components that Jeff's going to tell you about. One little REO short sale, I can figure that one out, but all the other components, he was developing, has developed a methodology. And I would tell you from his standpoint, he's great to work with, he and his team. We did this about a year ago, Jeff, I think. We were so far out in front of this curve. He'll come in, they'll get your records, they'll get your books, they'll tell you no, maybe, let's not put that one in, that's a bit of a stretch. I didn't like those days. But you get as much as you can, you get the numbers in there. It's not difficult, most of it's electronic in terms of the numbers. There is literally a need to go through and say, what's your justification verbally for having this one in the pool? And they'll go through that with you and again, kind of rate, prioritize what they think should be in there and what just seems to be a stretch. And I have the utmost confidence in the process that he's put together. And just to give you a quick idea, I'm a $200 million bank. Our claim is over $15 million. So they're going to find it. And there's not just one or two components. There's several components, and he's developed the methodology for the forensic evidence. As I told a group in Pensacola Beach a few weeks ago, I had known Fred Levin for a long, long time. And I don't think there's anybody I would have more confidence in. I was in the Florida legislature when we passed the monumental tobacco Medicaid litigation, and I was chairman of the Appropriations Committee as those funds were coming back into the state treasury in Florida to assist us with our Medicaid expenses, saving taxpayers thousands and thousands of dollars paid by tobacco interests. But I saw Fred and the team he put together. I watched how they knew how to get people like Jeff and Warren Averett on the same team with them. I knew he knew how to process something of this significant magnitude, and it's going to be a mess. I mean, as Mark well told you, it's not going to be easy, but I'm confident that they have the team that's going to pull this together. And as I said, we signed up with them probably about a year ago and started working on these numbers. And probably the best thing for all of you wondering today, we haven't paid them a dime yet. So works pretty good. I just regret again that I got to leave. I'd be glad if y'all want to call and talk to me personally. Gulf Coast Community Bank, easy to find on the website. Talk to me personally some more about this. I regret that I have to leave because I'm sure somehow in Fred's comments, he's going to figure out a way to tell you about how Florida's going to beat Georgia this weekend. Well, we won't go there yet. Thank you so much. Here's Mark.
Thanks, Buzz. As I said, David Shelby, Fred, and I have put together what we think is a terrific team of experts. I'm going to introduce now Jeff DeWeese. He is going to take you through, as I said, the issues that we look at when we are evaluating a bank claim and the significance of those issues. When you leave here today, not only do I hope rattling in your head is I've got to do something immediately because I've got a January 1 deadline and an April 20 deadline, but I want you to be well apprised of the different issues that you're going to have to deal with in terms of having your claim evaluated, the documents that we'll be looking for, the different issues that we'll be fleshing out. So, Jeff, if you can take us through that. Jeff DeWeese.
Thank you, Mark. As Mark said, we've been involved in bank claims for over a year now. We've done somewhere between 6 to 10 claims that we've put forward. Of course, none of those have been compensated to date. Our approach that we've put together is much a team approach. We work very closely with Saltmarsh, Cleveland, and Gund. They are our panel of experts that once we have documented your claim, we sit down with their banking experts and we have to defend your claim to them. So they would be the opposing expert that we would be facing as we go forward. In order to do bank claims, what we have put together is a uniform process that each claim will be put through. That way we have uniformity in presentation, we have uniformity in approach, it's repeatable, BP can get comfortable seeing the same approaches at each bank so that they get comfortable with how we've done it. That way, if we're going to discuss various aspects of how we approached it, it's uniform. So once that issue would be decided, we can get concurrence one way or the other on each bank claim that's involved. So the approach we've taken is one that is repeatable, and it tries to minimize the impact on each of the banks with regard to utilization of their resources. We realize that community banks have finite resources of time and people they can devote to this process. So what we've developed is really a template that we will send out. It's an electronic template. It analyzes your balance sheet and your income statements. It gives us a detail of what occurred within your write-downs, what occurred historically through your REO, as well as what's happened in your loan loss reserves throughout the period. The approach we've taken is one of what did your bank expect in 2010 but for the oil spill. As many of you know, the recession had an impact. Additional capital was being required in banks across the region. So many banks were in a capital raising campaign. They had projections. They had budgets that had been put in place so that they had an idea as they were out in the community what 2010 would have looked like if the spill had not occurred. In many cases, we're finding banks had a 2-3 year plan on when they were raising additional capital, what kind of growth that additional capital would return. Then what we do is we undertake, based on the templates we've provided you and the initial documentation that we obtain, we do an analysis of what your bank's losses could be based on what occurred in the bank in 2010, from May 2010 until the end of the year. We're very fortunate in banks in that the documentation is really very good, as we see across all claims. Having done hundreds of claims with regard to the Gulf Coast Claims Facility and now the MDL panel, documentation in claims in general is a concern that we've had across the board. They're struggling with it right now in New Orleans for the small business. We don't have that issue with banks. Sometimes we have too much documentation when it comes to banks. We have loan committee meetings. We have risk committee meetings. We have credit committee meetings. We have minutes that we can go to and get a feel for what was going on in the banks before the spill, during the spill, and after the spill. When we look at bank claims, the real numbers materialize in the loans and in the other real estate. We do see, we can immediately, when you send your template back, within 2 weeks, we can do an analysis that will show you the cliff that occurred in 2010. It is uniform. We've seen it in Alabama banks that look exactly the same as Florida banks. We had bottomed out a little bit, okay? We were starting to see an improvement in that first quarter of 10. In many cases, we were starting to see the improvements that we expected. And then we had the oil spill. All of a sudden, the banks had people pulling money out of their banks to continue paying their bills. They had people go late. They had the loans aging. It really was evident along the coast. Well, what we've done as far as comparing banks to other regions, we have gone out and looked at what happened in the rest of Florida, in the rest of Alabama, in Georgia. And what we've seen is that the improvement that was occurring in 2010 really started to continue in other regions around the Southeast. But that did not occur in the Gulf states, along the coast and inland. So what we do is we go, and after we get the initial analysis of what occurred, what reserves you had, what your ORE looked like, we will come in and sit down with your lenders and with your credit committee, and we will identify which of your loans were impacted by the oil spill. Now, it's very clear when we go through the documentation that not all of your loans were impacted by the oil spill. Some were just economic, and we're not going to waste time on those. But a lot of your loans had a very definite impact based on the borrower's situation, and what was occurring. We're also seeing that ORE started to come back, and you started having additional foreclosures, properties coming on the books, and you'll bring in more and more real estate back on your books. And then we also saw that the real estate you already had continued to decrease in value. What compounds that is the additional appraisal fees, additional legal costs that are surrounding that entire situation. So we have to come in and look at that process on the properties that you owned. What's very important that Mark discussed is right now it's important for you to move forward to document those claims right now, because in 2017 you may not have the same lenders on your staff. You may not have the same documents in your files. So it's very critical right now as bankers that we document everything about the loans and the properties that have been impacted to preserve that for trial, because of the distance it may take for us to get to that end zone. So we will come in, we sit down with your staff, because at the end date, this is the bank's claim. We can show you the process to calculate your damages, but it is what occurred in your business. So you will be an integral part of the decision process and justifying what those claims are. After we've developed that claim, what we do is then we go sit down with the panel that we have at Saltmarsh, a panel we have in Birmingham of our bank group, and we actually argue the loans and the real estate and the losses that we see. Now, there's going to be ancillary claims that come into each of these banks. You're going to have lost interest income. You're going to have banks that are claims that you may not have ever taken back, but they went to non-accrual status. Okay, so you're going to have losses there that have to be quantified. You'll have fees that may have been impacted. We've seen massive decreases in loan applications that occurred in and around that time, both in commercial as well as residential mortgages. The real estate market really started to bottom out at that point. So we see a lot of these indications that have occurred in each of the banks. All of this effort to date is quantifying 2010 damages. We'll look in 2011 to see if the bank has righted and improved. One of the things that the Gulf Coast Claims Facility and the MDL panel has looked for is, has there been improvement in 2011 in the claimant situation? A lot of times there has, and a lot of times there haven't. One of the issues we deal with regularly is that banks sometimes incur a death spiral. And that's where we've seen several of the banks we initially started talking to aren't around today because they've been taken back by the FDIC because the death spiral began. Unlike a person that owns a piece of property, the oil spill happens, they don't want to pay that diminution of value claim because it hasn't been realized by the individual. That property may go back up. But in banking, as you all know, you have to take that charge when the loss is known. And so at that point, your earnings have been negatively impacted, your capital's been negatively impacted, your ability to lend money has been negatively impacted, and left unchecked and without really, serious action on the part of the bank, it could impact the ability of the bank to continue in the future. With less capital, your growth is limited. So the next aspect of a bank claim that we work with is to try to determine what the future damages of that bank are and what would be incurred. We've looked at, because when we make a presentment, it has to be for a sum certain under OPA. So it has to be, these are what we think our damages are, and this is where we're going to move forward on the claim. And so what we do at that point is we look at the but-for condition that the bank expected prior to the spill, and we compare that to the new actuals and where the bank expects to be in 12-13, and look at the difference of what's occurred. By doing that, we're able to quantify the impact on the value of the bank going forward, so that we know what the damages were in the period that we incurred, and we can also do a reasonable estimate of the impact that it's going to have, the spill will have on the long-term value of the bank and the earnings of the bank. So it's really critical that as we move forward, as we move forward, is to preserve this documentation that's already 2 years old, so that as you move forward with your claim, you do have the ability to prove your damages in 2015 or 2016. That's critical. Secondly, the process that we've put together is extremely uniform. You're going to get the exact same templates and exact same data that every other bank that we're working with is getting, because due to the tight deadlines that we have here in the next 60 days, we have to be able to analyze each bank individually and leverage all of the talents of Carr Riggs, the talents of Saltmarsh Cleveland Gunn, and our firm collectively working as a team, because what we have found is we're going to have conflicts. We have a large banking practice at Warren Averett. Saltmarsh has a large banking practice. Carr Riggs has a large banking practice. So if we're your auditor, we're not going to be able to do your claim. We're going to have to refer that within our team so that everybody working together can get that claim accomplished for your bank. But by having a uniform approach, we know that all of those claims will look the same when that final presentation is made. That's a brief overview of where we go in the claims process. If anybody has any questions, I can take them now, or we can talk about them after the presentation. Yes. Yes, sir. Yes, we did this is Jack Greer with Bay Bank, and we did their initial interim claim for the GCCF as we move forward.
So my question was, like Mark said, you have to quantify your claim. If y'all brought ours forward, I can't remember, to try to quantify the thing initially, Feinberg, and they were offering settlements of 2 years of doubling your first year's claim or something. All that, of course, has gone away, and it never occurred in bank claims. But I want to be sure that we're doing what we need to do to be sure that we meet those deadlines. I know, is Cunningham Bounds, Mark, one of the steering law firms, or do you know?
They're on the plaintiff steering
I thought they were, but I wasn't sure. Okay, so I guess we'll be being advised by them to be sure we got what we need. But my question was, do we need more from y'all at this point?
Well, we have quantified your 2010 damages right now. We did that when we made the interim presentation to GCCF. So the only other aspect we would have for your particular bank would be to quantify those future loss damages to move forward. So we're in a good position there, and Cunningham Bounds has provided us enough documentation so that we can continue to look at that. Yes, ma'am.
You mentioned that you do an analysis from May 2010 within the year, into 2010. But to do the comparison you're talking about, it sounds like you'd have to back up and get earlier in the year or go back to the prior year for a comparison.
Great question. The question was, we have to look at prior years. Yes. The templates that we will provide you will go all the way back to 2007. Okay? We're going back and doing 2007 analysis, 8 analysis, 9 analysis. That's very important to this process to show that the bank had what the recession had done to the bank, what it looked like pre-recession in a lot of areas, and how it was starting to improve, or what the condition was at the time of the spill. So you're correct. We will be looking at 2007, actually through 2011, to get an impact on the bank. Any other questions? Okay, and I will be here after the meeting if you have any questions or would like to discuss anything else. And with that, Mark?
One of the comments that Jeff made, very, very important, which is the template. You all need to get a copy of that so that when you return home, and if you're interested, you can immediately go to work checking off the various items, putting together the documents so that the evaluation can be done. We're going to now move to the next phase of the program, but before I introduce Fred, James, why don't you and David come up here and join the panel, because after Fred has completed his remarks, then we're going to open everything up to questions, and that way we'll have our full panel here and we can answer your questions. I now want to introduce my partner, Fred Levin, not only to talk to us a little further about the mechanics of the bank claims, but as importantly, to explain to you how we would propose, how the lawyers and our expert teams would propose to handle your litigation, what would be the financial issues involved, so that when you leave, you will know what's all involved, and you'll have a mechanism to report to your boards or whomever you need to decide whether this is something that you're interested in. We've got, I think it's very important in this litigation for you to be represented by not only players that are experienced in this, but particularly members of the Plaintiff Steering Committee, members of the Executive Committee. There is a reason why federal courts choose lawyers to lead this litigation. If you looked in your newspapers the day after the spill, you would have concluded that every lawyer who had a beating heart was an oil spill expert. Logic tells you that's probably not the case, and in fact there are only a handful of firms, in my judgment, who are capable of undertaking this type of litigation and seeing this litigation through to the very end. We're lucky in our firm to have our partner Brian Barr, who's one of the 4 lawyers leading the litigation in New Orleans. We're lucky to have a bunch of talented lawyers involved in handling cases. For everybody knows David Shelby, but his firm are experienced in litigation, experienced in complex litigation, and these are the types of individuals with experts like James Bell that you're going to need for this type of litigation. You cannot undertake litigation on a bluff. You don't undertake litigation to think that you are going to scare somebody and they're going to come sniveling to the bargaining table. If we can get BP to the bargaining table, that's great. That's what we want. The sooner the better. But when you undertake litigation like this litigation, you undertake it to go all the way to trial. Remember, the big settlement in BP occurred the night before the trial. There's a reason for that. Trial, trial, trial settles cases. So you've got to be prepared to go all the way. You've got to develop the resolve and stick with the resolve. With that said, I want to introduce Fred Levin, who is going to, I hope, bring this home, and then we'll take questions.
Thank you, Mark. We're talking about litigation. The firms are as he stated, there were a number of firms who, like I say, every time you looked at television or you looked at the newspaper or listened on the radio, that you would have thought were experts. These all concern the settlements, because the settlements are simple. I mean, well, it's a formula, and if you fit the formula and the accountants give you the information, that's real simple, and you go ahead and you send it in, and they'll send you a check eventually, hopefully. All right, what we're talking about today is not the case. That's not the case. We're talking about litigation, and that is expensive. I'll give you an example. We just concluded, I guess about a year ago, a case in West Virginia. Our half of the out-of-pocket costs, there were 2 firms, was over $6 million. You say, how's that possible? These people who call themselves forensic economists, some of them go to $1,500, $2,000 an hour from the time they get up in the morning till, I mean, it's almost ridiculous. And that's what we're going to face. So what you'll see, and even a lot of litigation firms, if you don't have enough cases, they're not going to get involved. So the first thing you do, if you've had a law firm involved with you, is tomorrow call and ask them, do you intend to handle this case through litigation? This is not going to settle anytime before you have to make a decision. So the first thing you do in regard to Cunningham Bounds, I assume they will be willing to go forward. But there are a lot of firms, including firms on the steering committee, that are not going to take cases, but mainly because this is no slam dunk. I mean, BP will have the top experts in the country. They've already bought off everybody in Alabama, I understand. All of the University of Alabama economists and even Auburn economists. Well, if there is such a thing. But but anyhow, and they did nothing more than what we did in Florida. We went to the University of Florida and Florida State University, and we grabbed the best people to come in and testify. Anyhow, as I said, it's very, very expensive, and BP has taken the position that they're not going to pay this. You made a loan to John Doe. John Doe got affected by the oil spill. John Doe made his claim. Why should we be responsible to pay twice? And in front of a jury, that's a pretty good argument. I mean, and there are law firms that also, lawyers, even in our office, have said, "Are you nuts? Do you know what this is going to cost?" And so, like I say, it's not a slam dunk. It's not the settlement. All right, so we then go, it's litigation. So we file the presentment, and then we file the lawsuit. Then what happens? All right, as Mark said, if they don't decide to roll over, then we go to fight this case in 2016, 2017. Some of you, if we don't get any money from BP, may not be here. I mean, the FDIC. And I met with the FDIC, Tom Jaginski or whatever, met with him and a whole staff of people and tried to explain to them that this is an asset. It's an asset of the bank, this bank claim. Now, let me tell you what I consider the asset to be, because I've got a lot of shares in a local community bank in Pensacola, not Buzz Ritchie's, and paid a lot more than the 60 cents a share it's selling for now. But we're prepared to file the claim, and it's about $12.60 a share if BP pays. So as a stockholder, this becomes significant. All right, why should you? All right, first, why should you do this? Well, let's say that all of us, or all of you, will at some point face the FDIC. They come in regularly. And let's say that you're in trouble. And what we would do, and we have done, is we then make a presentment to the FDIC, and we say, listen, this is an asset. This is a claim that we believe is worth, in my bank situation, $12.60 or something like that for each of the shareholders. FDIC says, we don't think it's worth anything. Then why don't you let us keep this asset and you go ahead and take over? And of course, all hell breaks loose at that point. But if they don't believe it's an asset of the bank, then why don't they let us keep it? But anyhow, we put that in that file, and it is a legitimate claim. All right, why should you do this? All right, let's say you're not in any real trouble, and all of a sudden in 2014, BP rolls around and decides to pay. Now, they're not going to pay me $12.60, but they may pay me $6.30 a share for the stockholders. Well, unless you own 100% of your bank, at the next time when that other stockholders hear about this, they're going to come to you and say, why didn't you do something? Well, we just didn't believe that this was going to go through. $6, or in my situation, $6.30, somebody's head's going to roll. Like I say, but if you own 100% of the bank, don't worry. If you don't have but one stockholder to worry about. So anyhow, why should you do it? Well, those are two pretty good reasons. One is we're going to back you up with the FDIC. We're going to send the documents to them showing that the claim is of value. And the other reason is they may pay. All right. Well, what is this going to cost you? And are we really confident, or in many instances, and you've dealt with litigation lawyers, and they sometimes will tell you things that maybe just in order to run up fees and things of that nature. All right, so then the question becomes, are we really serious? Do we really believe this, or am I trying to get in your pocket and have you pay me or pay our firm? Well, to show you how serious we are, we're going to go ahead, and if you'll see, when you read through your contract in there, we will charge 1/3 of anything we recover for you, and plus the cost. If we don't recover anything, we eat it. If the FDIC decides to come in as they had in two situations that we had, they decide to come in after we've paid the accountants, after we've paid the economists, after we've done all of this, they come in and take the bank over. We eat it, because I went and talked to them. I said, listen, we've done all this, and at least let us continue on with the case for the benefit of the government. And you would think that would be a logical thing to do, but I'm maybe a little too logical for some country boy like me from Pensacola. It just doesn't make sense to me what in the world they're doing. And because, believe me, the settlement with the federal government has absolutely nothing to do with the bank cases. Anyhow, from our standpoint, we're representing, I believe, about 15 banks, and this becomes important too, because we can share the expenses. In other words, the same economist that is going to testify can testify. What we would hope to do is put 4 or 5 cases together and bring it to in one lawsuit, have one of the economists testify, or even do similar to the multi-district litigation, get some of these issues taken care of, and then just go to trial on damages. But anyhow, we also have a few other things going for us in West Virginia. One of my law partners is a guy named Bobby Kennedy, Jr. He's the son of the former Attorney General. And when he's not the greatest lawyer in the world, but when he stands up and starts talking to a jury about Uncle John had this to say, and when Uncle John came in and jurors are crying, and it's fairly effective. But anyhow, bottom line, our contracts are in these files. We believe in the case. We believe that let me just say this: the Christmas party is going to be too late. When you're sitting around at your Christmas party this time, and some of the directors are there, and somebody says, "Well, I heard that some bank filed a presentment." Unfortunately, it takes, as Jeff will tell you, it takes a lot of work. Hopefully, we can get it done in 2 or 3 weeks. But if we've got to make the presentment, you've got to do it for a sum certain. You've got to back it up with documents. So, and it's not as simple as you think. My thought would be that you go back, what's the date, Thursday? Certainly by next week, make a decision. It's not going to cost you anything. It's really, it's a very simple situation. Just call us, call whatever law firm you want to call. Just make sure they're going to take the case. It's not going to be, just filing a presentment. Because we would hope we would be able to file all of the presentments by the middle of December. And then they get the 90 days. They'll, of course, at that time, they're going to deny it. And then we file the lawsuit. You got to have time to file your lawsuit. Also, there are a lot of things considering which is the bank, which jurisdiction will be best for you. In other words, for example, let's say that I do have Bobby Kennedy come in with me. He may not sell in certain areas, but he could sell in certain other areas. So a lot of these factors come into play in litigation. I think that pretty much covers the things that I wanted to say. These guys have done such a good job in presenting what the whole scenario is. Are there any questions for me before we open up the panel for any of your questions? Now, I think at some point when all of this comes to a head, somebody's heads, although I heard today they were all career service, so I guess nobody's head is going to roll. But anyhow, in answer to your question, that they have not done anything. Now, we did file a letter or an affidavit with the FDIC for a bank that was real close, and they have backed off. So, I mean, as to whether or not they officially are doing anything, well, you did file a letter with one of the banks, with the FDIC. So, maybe it will work. I think when you tell them, all right, you don't believe it's worth anything, give it to us. And that's where it's going to hit the fan, I think.
Does it make any difference whether a bank claim be made in the name of the holding company or the bank?
Let me just say this. I'm a litigator. What happens is the smart guys make all those intelligent decisions, and then they turn the files over to us, and it's up to us to convince a jury. It's the bank. Well, I guess the holding company could have losses. Well, let's see. There's something legally called the Palsgraf theory. I don't know whether or not you can take it from the bank has the loss, and I own the bank, and therefore, in answer to your question, it's the bank's claim, because I just went through this with St. Joe as whether stockholders would. Stockholders in Alabama, Louisiana, Mississippi do not have a claim for losses of the corporation. That I know. Florida, there's a good chance that they might.
I was just curious, are there any community banks in the 3 or 4 state area here that haven't already filed, retained and filed? Is there anybody here that hadn't already started the litigation process?
I don't know. I mean, there are a lot more than I think that we realize as to how many have done nothing but done the CF claim and then just figured, well, they turned me down. But the important thing is to go to your law firm and say, now, are you going to handle this all the way through? Because I'm assuming that whatever banks here that have already filed their claims, that they've filed them pretty much pursuant to what Jeff has said, and it's a lot bigger than what a lot of people think. In other words, so it's a two-pronged attack. One is getting the right firms, and then getting the right accounting firms and the right law firms that are going to take this and spend the money. I will say this, that just as a practical matter, if we only had 1 or 2 bank clients, no. I'm not going to spend $6 million on the chance that I can get you, or 12 million or 13 million, because if I spend the money and we don't come out, then I've lost it. So the only thing, like I say, if you've already filed your claim, make sure that you're, I doubt if any of you have filed a presentment yet. You may, I don't think so. We've been looking for a form of a presentment by a bank, and so you hadn't filed your presentment. And so just, I think, go to the law firm. Are you going to file a presentment? Who are you going to use to get the facts and figures? And are you willing to take the total risk? And I think that that's 3, 4 pretty good questions to ask. Yes?
I want to be clear on the jurisdictional issue, because obviously you guys think this is going to trial. So for Alabama banks, talk about jurisdiction. Where will these cases be heard in Alabama? What was the question?
Where the question is, what jurisdiction will hear these cases? It's normally up to the plaintiff, which is our banks, in order to pick the jurisdiction. Now that can be switched back and forth. We could go to, if we wanted to, we could go to Montgomery, or we could go to Birmingham. It is conceivable that, Mobile, you look for, you file it. Now they want to try to move it, but as long as the court has jurisdiction, every federal court has jurisdiction. Now the question is something called venue, so if you file it, they could remove it or send it to another court. What would probably happen is the law firms that are handling these cases would probably try to all get together, find a favorable judge, file them all there, rather than, I can tell you, I doubt very seriously whether a judge in Mobile is going to listen to one case and then one in Montgomery, one case, and one in Birmingham, 6 cases. They'll send them all up there, I would think. And they got the power to do that. Federal court does. Yes? No, the question is, the template that Jeff DeWeese discussed, is that something that the plaintiffs came up with, or is that something? No. In fact, first time I believe we ever heard it was after they came back. What they did, we said, look into this and see if, in fact, it's a viable claim. I mean, BP says it's not any good, and they make a pretty good argument. Why would they have to be responsible twice for the same claim? So we turned it over to the different accounting firms, and Jeff was the first firm. Warren Averett was the first firm. They went through it, and very, very expensively went through, met with the banks, and then they came up with an idea of what they felt. This isn't anything plaintiffs have done. They then went to another accounting firm, and the other accounting firm, which is mainly that other accounting firm, audits banks. And they presented it to the other accounting firm, and they went through it. Some of them they said, no, that won't go. Some of them they accepted. And so you had, now that brings 2 witnesses for us to the table. But anyhow, no, in answer to your question, we had absolutely nothing to do with it. My thought was, when I first turned it over to them, was my bank stock was selling for $32 a share. Now it's 60 cents a share. Why can't we get the difference in, but they said that doesn't work. Not that the stockholder, why can't the bank get the difference? And it made sense to me, and that's what I was trying to get them to go along with, but they said that don't meet GAAP or GAAP or something. All right, any other questions? We got both David and James here, or actually any of our people that you got any questions about. Oh, David?
Yeah, there are just a few things I'd like to say. We had a meeting in Pensacola, about 2 or 3 weeks ago. The group that we had, the Florida Bankers Association, was there. Linda Charity, I call her the superintendent of banks. It's a little different in Florida. Was there, and we had a very good meeting. There were a lot of banks, and the conclusion that we came to there was that it's in most any situation it's like this. United, the banks will prevail. If you can develop a strong coalition, I think that there will at some point in time there will be a force too great for BP not to deal with the issue. Divided individually, you'll be too weak, and BP, I don't think you'll be able to prevail. But I think if you can, if we can come together and we can, form a coalition, and that's basically what we're attempting to do. We'd like all the banks that have a claim not to be left out. Time is of the essence. You're going to have to take some action. This morning I met with John Tomlinson's partner, Ron Jones, from Beasley Allen's firm. And, Ron and I had a meeting, and, what we talked about, because he was on the negotiating committee, when they were trying to determine who's in and who's out, whose claims are we going to settle. And, there's, how that came about. I have a theory, And the theory that I have is that the banks were not at the table. There was nobody on that committee that represented any banks of any substance. 2 or 3 maybe, but they just weren't at the table. And the lawyers that were negotiating the deal with no skin in the game, the banks were just left out. If there had been 100 banks represented, if Joe Rice from Charleston, South Carolina, who was the chairman of the committee, if Joe Rice had 100 banks, the bank's case would have been settled. But you know, it's like Mr. Harrison said. To some degree, you were duped. Originally they led us to believe that they were going to come up with some global coalition that was going to pay everybody what they thought they deserved. Well, it's just not that way. Now, this is the case, though. You know, as a lawyer, when I first started practicing law, what I found out, and it took me a while to find it out, if I showed up, I won at least half the time. If you do not show up, you will lose every time. And in this particular instance, time is of the essence. I think the banks, I've met with enough good lawyers, people that are in the game. I feel confident that there is a claim, a valid, legitimate, legal claim that the banks have. Now, I feel this way about it. Under this new settlement, I don't know if y'all are familiar with it yet, but it's amusing to me because we have gotten many different types of claimants in North Alabama. It's hard for me to buy that a car dealer in Heflin, Alabama deserves to get paid and a bank that suffered losses doesn't. You know, a chiropractor in Florence, Alabama can file a claim, and if he meets the test, he gets paid. And a bank doesn't get paid. Now, excuse me. I mean, y'all are the economic heart of the community. If the community suffers, y'all suffer. And so that's kind of my 2 cents about that. But time is of the essence, and you're going to need to take some action fairly soon. Malden and Jenkins this morning had a conference in Birmingham, and Bill Curtis is here from their firm, an excellent accounting firm. I know somebody failed to mention you, but these are good banking accountants, and they can do this kind of work for anybody that needs work done. Does anybody have any questions? Okay, what would y'all like to cover now?
I just want to make a couple of comments. We've been taping this presentation. We received word that there would be some banks who would not be able to attend today, or maybe you have members of your board or other officers in the bank who wanted to find out what the presentation was about, the substance of it. So we have been taping this, and in your packet of information is a website that if you'll go to bpspilltv.com, there's a piece of paper in your packet. You can go on this. This is a website that we've put together that we provide information about the spill and the litigation. This entire presentation will be on it and available to you and others to watch. If we can do anything, they'll be in the packets. There's contact information. If you get home, you have other questions. If we can do anything to provide you information, we will certainly do that. On behalf of all of us, we want to thank you for coming. Thank you, John, for putting this together and for hosting this. David, thank you. David is, as soon as we get done, I think David is offering cocktails and hors d'oeuvres, so everybody stay around, have a drink, and we'll be here to answer questions. With that, I want to thank Carol and Brenda for their hard work in putting all the packets together and getting the information out. We appreciate you being here, and thank you for listening.